thing we have to fear is
in war,
fear itself.
there is no substitute for victory.
Let us never negotiate out of fear.
We stand undivided, forever united, fighting hand in hand for the liberty we've earned, for glory and honor, for our sons and daughters, ever mindful of the lessons we've learned. Let the torch of freedom burn.
You found your way to the intersection of faith and politics. That's WallBuilders Live, and you can find out more at our website, wallbuilderslive.com, and also at wallbuilders.com. I'm Rick Green here with David Barton. And, David, we cover a lot of different topics on this program. Today we've got a big one that, man, I was surprised at how many people paid attention to it just a few weeks ago when President Obama did his stroke of a pen amnesty. And a lot of people that maybe had kind of tuned out politics said, wait a minute, this is one guy making laws. You know, something from elementary school on up just doesn't sit well with the idea of an actual free government. It sounds more like a tyrannical government.
Yeah, and it's not supposed to happen that way. And by the way, we keep calling it an executive order, and it's really not. He's been so criticized for executive orders, he doesn't do them anymore. He does what's called presidential memorandums. He's now issued more than any other president in the history of the United States, more than all presidents total, essentially. And it's his way of getting. I didn't issue an executive order on that, but we'll call it an executive order because we've got that Texas axiom that if it walks like a duck and quacks like a duck and looks like a duck and sounds like a duck, it probably is a duck. And so this has the same effect as an executive order, even though he titled it something different. But the one he did on immigration, it essentially legalizes 5 million illegals. We'll just take you around the law, ignore the law. Now, according to Article 2, Section 2, he's supposed to uphold the laws of the United States, but let's not do that. We'll just ignore that. It also defers deportations, and that's, again, ignoring the law, not upholding it. It ends a program that was called Secure Communities. That was one created under President Bush in his second term, and it's intended to help government find and deport illegal aliens. So he's now ended that. And then in the immigration courts, what they want to do is end the backlog of pending cases, and so they're getting rid of what they call the low priority persons. And we saw earlier that's a bunch of murderers, and that's a bunch of rapists, and a bunch of whatever. And so it really is not a good deal. And so as a result of his executive order, you've had some 25 states and nearly 70 members of Congress who have joined in a lawsuit against the president that he doesn't have the right to do that. Now, just talking executive orders for a moment, they didn't start numbering executive orders until Abraham Lincoln. And so starting from Abraham Lincoln, now there were plenty before that, but starting with Abraham Lincoln, you've had about 14,000 executive orders, and only a handful have ever ended up in court. Because most of the time the president knows he's just used that to help him carry out existing laws, not to write the law. So,
and these are, I guess, across the board: Republican, Democrat, virtually every party, virtually every president, or maybe even every president.
Well, every president's used them, starting with George Washington. Well, not every president. Some president, John Quincy Adams, I don't think had an executive order. Some only had one. I mean, it wasn't a big deal to say, guys, here's what we're going to do. Didn't need to write an executive order because he could tell them all. Well, now, when your Department of Health and Human Services, which is one of 21 cabinet-level agencies, when that one department is now the world's 6th largest government, you can't quite get them all in the White House and say, guys, here's what we're going to do.
Yeah.
So you now have executive orders a lot more. But here's 3 examples where the courts have overturned a president and said you can't do this. One is Harry Truman. And back in 1950s, Harry Truman placed all steel mills in the country. He put them under federal control, and the court said, you can't do that by executive order. You got no authority to take private businesses and incorporate them. So that one was an executive order the court struck down. In 1995, President Clinton issued an executive order that said the federal government cannot contract with organizations who have strike breakers on their payroll. You can't do that. Everybody is able to compete in government contracts. And then back in 1968, you had Congress that prohibited the creation of presidential commissions. But what Richard Nixon did, I mean, we'd had so many commissions started by then. Richard Nixon, he just tried to dismantle several agencies simply by executive order. It just said, by executive order, this agency no longer exists. And you can't do that because Congress created the agency. So there's 3 examples, and that's about it out of 14,000 where the courts have said the president went too far. But in this case, they're likely to side. It's likely to be the 4th one because the president has not only violated laws, he has rewritten the law for his own intent. And so this one, I think, will be struck down by the courts. And that makes, I think the number now is 9 times the current Supreme Court has struck down Obama measures.
And many of those were
unanimous.
Unanimous, yeah, which is really weird since you got, 2 that he appointed. Kagan
and Sotomayor he put on the court.
Yeah.
And even they say this is too far. So David French, who's with the American Center for Law and Justice, an attorney, great attorney, he helped write the brief for the 68 congressmen who weighed in on this thing, and that's a big deal when that many congressmen weigh in. But David will tell us more about what's going on in the case and what the brief looks like.
Stay with us, folks. David French from American Center for Law and Justice when we return on WallBuilders Live.
This is David Barton with another moment from America's history. Often today, it seems that the federal government has become too intrusive into local matters, and federal micromanagement has now unfortunately become the norm in education, law enforcement, religious expressions, and even on what is and is not moral. Strikingly, the Founding Fathers had intended that the federal government never intrude into any of these issues. As Thomas Jefferson explained, taking from the states the moral rule of their citizens and subordinating it to the federal government would break up the foundations of the Union. I believe the states can best govern our home concerns and the federal government our foreign ones. According to Thomas Jefferson, the original plan was for the federal government to direct foreign affairs, but for the states and local communities to direct the domestic and the moral ones.
For more information on God's hand in American history, contact WallBuilders at 1-800-8-REBUILD.
Let the torch of freedom burn.
Welcome back. Thanks for staying with us here on WallBuilders Live. Our guest today, David French from American Center for Law and Justice. Hey, David, good to have you back, man.
Oh, thanks so much for having me.
Hey, we had you a week or two ago talking about several other topics, and you mentioned during that interview that you were working on a brief with regard to the case that members of Congress are filing against the president with regard to his very unconstitutional decision on amnesty, making law by himself, just kind of taking one little piece of the Constitution and throwing it out at a time. And here's a big part of the Constitution getting thrown out. Tell us, how, because people have been saying, hey, David, Rick, how do we stop this? What can we do? And everybody's kind of throwing their hands up. Sounds like you guys are doing something.
Well, right, absolutely. As a lot of your listeners know, 25, I believe at last count, 25 states sued the federal government over the Obama administration's immigration actions. We have filed an amicus brief, a friend of the court brief in that case, on behalf of 68 members of Congress, including Senator Cruz, including Senator Cornyn, Representative Goodlatte, many other people. So it is a strong brief, and it makes just a couple of points very clearly. One is the president simply didn't have the authority to act in the way that he acted. That there is a formula for when presidential. No one argues that executive orders or executive actions are always unlawful.
Right.
There are circumstances where they're lawful, and they're lawful when they are done pursuant to a specific act of Congress, and they're least likely to be lawful when they contradict a congressional scheme, a congressional set of congressional statutes. In this case, the president acted when there's already comprehensive immigration statutes. There already exist standards for determining immigration, naturalization, citizenship, and he acted in a way that defied this statutory scheme. So that's one thing. And
it's not, in other words, what you're saying is it's not an executive order that's in conjunction with or literally executing a law that Congress passes.
Right.
Fine, we're okay. Every president's done that. We got no problem with that. Reagan did hundreds of, no big deal there. That's what they're supposed to do. But when
Right.
you're doing it in contradiction to the law that's already on the books and doing against what Congress has done. How in the world do they, with a straight face, say I've got the power to do this just because he has a pen and a phone?
That's exactly – you said it better and simpler than I did, and that's exactly right, that Congress has already acted here, and just because the president doesn't like the way Congress has acted or wants Congress to change, and Congress hasn't, doesn't give him the authority to act. And then the other thing is you hear is that the president is saying and his lawyers saying, well, this is an exercise of what's called prosecutorial discretion. And prosecutorial discretion is that discretion that a prosecutor has to say, well, I can't prosecute every single case that comes on my desk, so I'm going to prioritize certain cases over others. I'm going to choose to prosecute others and I don't have time for others. And that's been a part of the American system for a very long time. But what is important about that, prosecutorial discretion has to be done on a case-by-case basis. In other words, a prosecutor can't say, well, you know what, I'm just not going to prosecute any bank robberies anymore. And so all bank robberies in the United States will not be prosecuted. That's not case-by-case determination. Right. That would be granting essentially a substantive right to bank robbers.
Yeah, or saying I'm not going to prosecute anybody over the age of 50. So that whole group is now, the law is not going to apply to them.
Right, exactly. So in this case, when he's trying to create entire categories of relief from immigration laws, that's not a case-by-case determination. That's essentially granting a substantive right to people, and that's not what prosecutorial discretion is. In fact, even his own attorneys, when mapping out the argument for why what he did was legal, noted the case law in there that says it has to be a case-by-case basis. And look, here's the deal. I mean, it's a pretty simple construct. If they're truly doing a case-by-case determination, the way his own lawyers say the way it has to be done, well, then he's selling a bill of goods to these millions of illegal immigrants, because he's telling them that they're essentially getting new rights, and he's changed the law. So who's he telling the truth to? Is he telling the truth to the courts and his own lawyers when he talks about case-by-case determination, or is he telling the truth to these millions of illegal immigrants when he's saying, hey, if you meet certain conditions, you're in? So there are real legal problems with his argument, and we're pointing those out in court.
Stay with us, folks. David French from American Center for Law and Justice is with us. You're listening to WallBuilders Live.
This is David Barton with another moment from America's history. In the case Lee versus Wiseman, the Supreme Court ruled that for an adult to mention the word God at a public graduation constituted both psychological and religious coercion against the students. Yet consider the actions of William Samuel Johnson, a signer of the Constitution and one of America's leading educators who served as the first president of Columbia College. At his graduation exercises, William Samuel Johnson declared to the students, "You this day have received a public education, the purpose whereof hath been to qualify you better to serve your Creator and your country. Your first great duties, you are sensible, are those you owe to heaven, to your Creator and Redeemer." Founding Father William Samuel Johnson believed that a public graduation was an appropriate setting to remind students of the duties which they owed God.
For more information on God's hand in American history, contact WallBuilders at 1-800-8REBUILD.
Let the torch of freedom burn.
We're back here on WallBuilders Live. Thanks for staying with us today. We have David French with us from the American Center for Law and Justice. We're talking about the case that he just filed a brief in representing dozens of congressmen pushing back against the president and his unconstitutional immigration stroke of his pen to make law with just the presidency suddenly as a dictator. And David, is this where we? So is this then? I mean, is this where Congress actually pushes back? I mean, when one branch exceeds their authority and steps on another branch's authority, we always talk about they need to push back. Is this the one of the key ways for them to do it? If you've got 60-something congressmen signing on to this brief, isn't that ought to be a loud message to the court that there's a definite dispute about this action that he's taken. I mean, obviously we'd love him to just overturn what he's done, but how does this fit into that whole pushing back perspective?
Well, I do think it is a message. Now, it's going to be up to the court to determine how it views the arguments, but I think when 68 members of Congress signed on to a brief, that's a very loud and clear message about the intention of those members of Congress. And one of the great things about our system is that there's more than one way to protect our separation of powers. You can file suit, as these attorneys general have done, and you can file briefs, as these members of Congress have done. And then Congress has its own freedom to act. And it will be interesting to see in the new Congress what they choose to do. So there's more than one way to protect the separation of powers, but obviously a key way to do that, a core method of doing that, is through judicial review. And judicial review has a history in the United States going all the way back to the era of the Founding Fathers, and part of the role of the judiciary is to determine the constitutionality of acts of government. And in this circumstance, the President of the United States acted against congressional authority, acted outside of the bounds of prosecutorial discretion, and these members of Congress are trying to hold him to account.
David, if you didn't do this, if this suit wasn't there and you didn't have this pushback both from the states and from these members of Congress, I assume at that point we would just be ceding that authority to the president, and it wouldn't just be Obama doing it. It'd be future Republicans, Democrats, conservative. They all say, hey, this is power we have. We're going to go make law on our own.
Oh, absolutely. I mean, if there's one thing that we know from history, it's that once you cross a certain threshold, future presidents will cross that same threshold again. I mean, Democrats should not expect Republican presidents to narrow the scope of their own authority. They will take the authority that they believe the presidency has, as defined by prior administrations, as defined by case law. I mean, it is the way things work politically. And that's why it's so critical to step in now and to say, we have to stop this at this point. You don't wait till another presidential election and believe that that will set everything right, because it's just as likely that the next president will look at the level of authority that President Obama exercised and decide to take action in the same way. And that's going to really hurt our separation of powers. It's unfortunate, and you guys do a tremendous job of educating Americans about the historical roots of why we have this system, why it is so important to separate the power of the commander-in-chief, the lawgivers, and the judges. Incredibly, because when those powers were combined, that's what a king was.
That's right.
A king combined those three great powers of government under one under one authority, and that meant tyranny. So our founding fathers separated them because they knew it would be a firewall against tyranny. They also knew that sometimes it wouldn't be all that efficient. And it's really discouraging and historically illiterate for the President of the United States to essentially say, well, he's got to act because Congress won't. What he's saying at that point is, I don't believe in our constitutional system, and then I believe that I have the authority to do what I think's best when Congress doesn't do what I say. And that is antithetical to our constitutional system. It's antithetical to the historical reasoning behind our constitutional system. You know, this is not just an old piece of paper we wave like it's got magic. It was a intentionally thought out document designed from the get-go to protect liberty and to protect the rights of citizens. And when you disregard it, you are placing in jeopardy the liberty and the rights of the citizens of the United States.
I'm sure glad you guys are there defending it. Last question as we go, timeline for how this thing plays out. Obviously it's going to take a while to do it, but this stand has to be taken. Do you see this as a 2-year battle? What do you think?
You know, I hesitate to tell my old lawyer joke that the great thing about America is everyone gets their decade in court. But, it's tough to say. I do think that this is the kind of case that will receive more expedited review than a normal one. So I would think, before the next president is sworn in, we're going to have there will be case law on this point before the next president is sworn in. Which direction that case law goes, well, that'll be up to the judges.
Yeah. All right, we'll see. We'd love to have you back for an update. David French, always good to have you, bro. Thanks for coming on.
Well, thanks so much for having me.
Stay with us, folks. Back in a moment with David Barton.
Hey guys, this is Tim Barton with WallBuilders. And I know you hear my dad and Rick talk a lot about our founding fathers, about the original intent of our nation, the constitutional heritage that we have, and really we've seen how far we've slipped away from that. And I know a lot of us, as we hear my dad and Rick talk, think, I wish there was a place that I could go and I could see these documents, that I could read and learn about the founding fathers firsthand, see the things they did. And I want to give you some websites today that can help you accomplish that very thing. If you get online, you can go to places like Library of Congress, and you can look under their Century of Lawmaking or historical documents. You can go to the Avalon Project, to the Founders Constitution, to Google Books, or even the Internet Archives, or you can just go to WallBuilders' website. We have a section for our library, and under that section we have different subgroups for historical documents, historical writings, even a place where you can get helpful links to find out more information about other websites where you can do research for yourself and find the truth for yourself. Friends, this is a time that we need to know who we are and where we came from. WallBuilders.com is a great place to go.
Let the torch of freedom burn.
Welcome back to WallBuilders Live. Thanks for staying with us. We're back now with David Barton. David, good stuff. I think it's great to have, as you said in the first segment, so many congressmen signing up for this. This isn't just one member of Congress saying, hey, this is our position as Congress. This is a big number, and what a chance. You and I both have talked for so long about the branches pushing back when another branch is encroaching, and it's great to see them doing that.
Yeah, it is great to see them doing that, trying to maintain the boundaries as specified by the Constitution, not let them be rewritten by one individual. But I want to go to something that you said. You said Reagan did hundreds of executive orders. Are you sure about that?
You know what, the number that was just coming to my head was like 180, and I can't remember. It seemed like it was an article I read by Spalding or somebody over at Heritage, but I know they all in the last 40 or 50 years did quite a few.
Well, actually,
am I way off?
No, Ronald Reagan did 381.
Okay, so it's 381. Right. I was thinking 180. Yeah, okay.
Yeah, he did do hundreds. You're exactly right.
But they were actually executing a law that was already.
That's right.
It was it was congruent, in other words, with that law, not against the law.
You did not find the courts having to strike down Ronald Reagan's executive orders. Now, let me ask you something else. And given all the presidents, and I pulled up a list here in front of me. And by the way, I got to go back and recorrect. John Quincy Adams did issue 3 executive orders. I said in the first segment he didn't. He did. The president who did not issue any was William Henry Harrison. But outside of that, which presidents do you think would have issued the most executive orders?
Man, I would think that this is a complicated answer. I would think a president who's dealing with an antagonistic, agencies where he has to be very specific in what Congress wanted, because like Reagan dealt with an entrenched bureaucracy. It was one of what he said was so hard to overcome. Even when he got Congress to do the right thing, he couldn't get the bureaucracy to do the right thing. I'm trying to think of a president that would have really been fighting that other than Reagan. Man, I'm drawing a blank. I don't know.
I've got one I'll give you, but let me give you three numbers first.
Okay.
Let's take Franklin D. Roosevelt. How many executive orders do you think he issued?
I guess he's in there longer than anybody else, so let's guess 500-600.
3,522.
Okay.
3,520. Now, let's go to number 2 on the list. Woodrow Wilson, 1,803. And then here's an interesting, let's put this guy in, Theodore Roosevelt, 1,081. Now, does anything strike you about Roosevelt, Wilson, and Roosevelt?
Progressives.
Progressives who want to expand government and make it really big.
Yeah, even Teddy being you would think he wouldn't be as liberal as the others, but he was constantly wanting to use government to do things government had never done before.
Oh, he talked about how he was really disappointed he had to go through Congress, and he was probably the first one to start talking about the stroke of the pen kind of stuff. So he was very activist in it. He left really the Republican Party to become the progressive, Bullmush Progressive Party. But here's one. Explain this one to me. This is the third most number of executive orders issued, and it's by Calvin Coolidge, 1,203. Now, why Calvin
I
Coolidge?
don't think of him as a liberal.
He is a huge small government guy.
Yeah, he was.
He is Thomas
fiscally
Jefferson,
conservative, constitutionally, wanted to get back in the. So why in the world is he doing so many?
Because his were to repeal all these orders given beforehand by Roosevelt and Wilson.
So they're not new. It's not a new executive order. It's basically reversing.
He's reversing stuff, and so just out of fun. Executive orders are a long part of American history, and when they're used wrong, they grow government like crazy. Obama and Teddy Roosevelt and FDR and Woodrow Wilson, when they're used right, they can shrink government in. Calvin Coolidge and others. So
that makes me think, David, of that. I mentioned Spaulding. I hope I've got that right. I think it was him that had done this article over at Heritage on executive orders, and one of the things he suggested was to have, when you come in as a new president, especially a conservative, and I think he had recommended this for W, but, if we have a new one in 2 years that's conservative, it'd be great, to review every executive order of the previous president. Now, this was before Obama. He was saying this, back even with Clinton. Review every one of those and do what you just said, reverse it.
I would examine every one in the last 20 years because you're only looking at the last 20 years, maybe a total of 600 or 800 total. And so go back through and see, especially sweeping ones like Obama has done, and get those things turned over. And that would be a huge limitation on the growth of government, is just reversing some executive orders.
Well, just the fact that so many people are paying attention to it now as opposed to in the past is a great sign that we have a chance of doing that in 2 years with a better president. Thanks for listening today, folks. You've been listening to WallBuilders Live.
We stand under